Hello everyone, welcome to Jurisprudence 2 lectures. I'm Marjina Sultana from Indraprasth Law College, Greater Noida. In this video, we are going to discuss the concept of ownership. The concept of ownership is one of the fundamental juristic concepts which has its origin in the ancient Roman law. In Roman law, ownership were termed as dominium and possession were termed as possessia. Jurists have defined ownership in different ways, all of them except the right of ownership as the complete or supreme right that can be exercised over anything. Let's discuss some important definitions given by the Austin, Holland, and Salmond. According to Austin, ownership refers to a right indefinite in point of user, unrestricted in point of disposition, and unlimited in point of duration. In this definition, Austin focused on three main attributes of ownership, namely indefinite user, unrestricted disposition, and unlimited duration. The first attribute, that is indefinite user, means that the owner is free to use or misuse the thing in a way he likes. For example, if a person has some land, he can use it for building a house or for gardening or for agricultural purposes and so forth. But this is incorrect as we cannot use the thing we own so as to injure others, so as to cause harm to others. For example, if I have a drone, I can use it and enjoy it, but I cannot use it to spy on my neighbor because it would amount to the infringement of right to privacy of my neighbor. The second attribute, that is unrestricted disposition, means that the power of the owner to dispose the thing owned is not restricted or hampered by law. He can sell or even gift it to anyone he likes. But this is incorrect. In some laws, a person cannot dispose of his entire property. He has to keep a certain portion of the land for his family members. For example, under Muhammadan law, Muslim has no right to bequeath more than one third of his property. The remaining two thirds must pass to the heirs of the testator. The third attribute, that is unlimited duration, means that there is no time fixed for ownership. It means that ownership it means the owner may own a thing and enjoy his ownership for unlimited time period, for unlimited duration. It is incorrect since almost under every legal system, state possesses the power to take over the property of any person in public interest. For example, Article 31A of the Constitution of India provides for the acquisition of estates by the state. The abolition of zamindari system in India, the abolition of privy purses, nationalization of bank, etc. are some example of the fact that ownership can be cut short by the state for public purposes and its duration is not unlimited. The next definition that we are going to discuss here is given by the Holland. According to him, ownership is the plenary control over an object. According to Holland, the owner has three rights on the object owned: possession, enjoyment, and disposition. Here, plenary control over an object implies complete control unrestricted by any law or by any fact. Thus, the criticism that is leveled against the Austin's definition would also apply to the definition given by the Holland, insofar as the implication of the term plenary control goes. The third definition that we are going to discuss here is given by the Salmond. According to Salmond, ownership vests in the complex of rights which he exercises to the exclusive of all others. For Salmond, what constitutes ownership is the bundle of rights which in here resides in an individual. In this definition, Salmond points out two attributes of ownership. The first one is ownership is the relation between a person and right that is vested in him. It is not wholly correct to say that ownership is the relation between a person and a right that is vested in him, as the most common and popular idea of ownership is the relation between a person and the thing. The second attribute, that is, ownership is incorporeal body or form, is also only partially correct because ownership does not only refers to the incorporeal body, it also refers to the corporeal body that is tangible in nature, for example, land, houses, car. Ownership is the exclusive and ultimate legal right to a lawful claim or title. This concept consists of a number of claims such as liberty, power, and immunity in regard to the thing owned. So, if you have ownership, you can possess and manage the thing that you own. You can use the thing, you can enjoy that thing, you can exclude others, you can transfer the thing, you can consume and even destroy an item or property. If you have ownership of something, it means that you are the owner. It belongs to you. The process and mechanics of ownership are fairly complex. One can gain, transfer, and lose ownership of property in a number of ways. In this slide, I am providing a simple example of taking ownership. When when someone buys a car, they take ownership of the vehicle. It becomes theirs. When I receive a gift, I take ownership of it. The gift belongs to me. When you inherit a house, you take ownership of the property. It becomes your possession. Now, we may conclude that ownership is the exclusive and ultimate legal right to a lawful claim or title, which comprises of powers, claims, privileges, etc. Ownership is in respect of a thing may be corporeal or incorporeal. The right relating to or connection with ownership are subject to the state regulation. That is, it can be limited or restricted by law. Ownership does not imply or indicate absolute or unlimited rights either of use, disposal, or duration. Thank you for watching this video on ownership.